Good afternoon. I'm Ellen Krug, the Executive Director of Call for Justice, a small nonprofit based in Minneapolis which works to increase the connection between low-income people and legal resources in the Twin Cities. Today is our 16th training session at United Way 211, Ceridian Corporation, and our training topic today is community mediation. We have a stellar cast of presenters, whom I'll introduce right now. Taking them in order, off to my left is James Henson, who graduated from the University of Minnesota Law School in 2011. He serves as a case manager and mediator at Community Mediation and Restorative Services, Inc. He completed Restorative Justice Conference training in 2008, a 30-hour Rule 114 civil mediation training in 2009, and he volunteers with several nonprofits in the Twin Cities. To his right is Elise Chambers, Program Director for the Conflict Resolution Center. Elise worked as a criminal defense lawyer representing adults and juveniles at the Minnesota Law Collective, a nonprofit she founded. She also created and managed a certified student attorney program in partnership with the Minnesota Justice Foundation, which provides law students the opportunity to help low-income clients while being mentored by practicing lawyers. Elise also ran the nonpartisan Election Protection Voters' Rights Coalition in Minnesota in collaboration with the Lawyers Committee for Civil Rights. She's been very busy. She loves growing the Conflict Resolution Center's programs and utilizing her juvenile justice experience to develop the Minnesota Restorative Services Coalition. And behind me is Jeanne Zimmer, who is the grandmother of mediation in the Twin Cities. She is the executive director of the Dispute Resolution Center, and she is the longest-serving executive director at the oldest community mediation program with over 30 years' experience in the nonprofit sector. She has a Master's of Nonprofit Organizations from Case Western Reserve in Cleveland. She is an adjunct professor at the University of St. Thomas and University of Minnesota and a guest lecturer at a number of colleges and universities. She's completing a doctorate in evaluation studies with a supporting field conflict management and serves on the council of the Alternative Dispute Resolution section of the Minnesota State Bar Association. As I said, we have people here with stellar credentials. Help me welcome them, please.
So thank you all for being here this afternoon. We're three mediators here just giving you some suggestions, advice on how you can make referrals to mediation and give you a better understanding of what mediation is in the Twin Cities and Minnesota area. So next slide. So what is mediation? It's really an opportunity for parties to resolve an issue or dispute or matter in a way that it's really driven by the parties themselves. The mediators use what we call a facilitative model where they help the parties understand each other. The mediators don't give advice, but really they help enrich understanding and help the parties come to an agreement to resolve whatever their issue they may have, or at least part of the issue, and so they can move forward. And it can, oops, give me back one. We emphasize 4 areas. One, it's voluntary. So we do community mediation, totally up to the parties whether they want to participate in the process or not. It's neutral, so the mediators aren't going to be telling the parties what to do, what they have to do. They're not going to be giving advice. It's safe and confidential, so there's statutes that govern the confidentiality of what they say in the mediation. The mediators can't be subpoenaed to go to court. And then the ultimate goal is to improve understanding amongst the parties so they can have the tools and information they need to resolve the issues. So who are the mediators? Each of the organizations in the Minnesota area has its own roster of mediators. Some mediators overlap between different organizations. And the rosters can be over 100 people, and they've all gone through 30-hour trainings. They all do annual trainings every year to stay current, and most of them are active mediators. And so we have mediators from all kinds of backgrounds and occupations. The mediators, like I said, use a facilitative model of mediation. They don't make decisions for the parties. And then some mediators are able to do mediations in other languages, such as Spanish, and sometimes we use interpreters, so all parties, we can accommodate as many languages as we can find interpreters for. So how the process works. First, we have a case manager who determines whether mediation is the right resource for the parties. So we do intake, get the basic gist of what the issue is, what the party wants out of the process, and we make referrals if necessary. Second, we determine who should be invited to participate. This is really driven by whoever calls. So if the issue is between, if it's a conciliation court matter and they want money from one other person, then that's fine. But if the issue is more complex and there need to be other people involved, then the case manager will talk about who the caller wants to participate in the process and who they think needs to be necessary. If it is like a conciliation court matter, for example, and they want someone who's not involved in on the court claim, then there might be some questions of why they want this person involved and who might be necessary to resolve the court issue to make sure that the right people are there. And we can also, the parties can also bring attorneys or support persons to the mediation, although the process is really meant to be between the direct parties involved. If the caller determines that, if the case manager and the caller agree that mediation is the right next step, then the case manager sends out invitations to all the parties involved. So the caller won't have to ask the other people themselves. The case manager will take care of that. And that's both, that can be through written correspondence, through email or phone calls, inviting the other parties to participate. And like I said, it's a voluntary process. So the parties, the case manager will invite, and if there's a decline, if another party does not want to participate, then the process would stop at that point. So scheduling, most mediation nonprofits are very accommodating to people's schedules. So we don't want to turn someone away just because they can't do it 9 to 5. So we do mornings, evenings, weekends. And so we're very flexible based on the party schedules, and we have mediators that can accommodate that as well. The mediation, we're gonna watch a short video, although I'm gonna prep the video a little bit here. So the mediation session, we start with just going over the ground rules and telling the parties what they can expect at the beginning of the mediation, and like you'll see in the video, sitting around a table in front of each other, having an opportunity to listen to the other side, talk, and then respond to the other party. So we're going to show you, at least this is an introduction to, do you want to introduce the video? Or? I would love to. Okay, so I'll let Elise introduce the video.
Actually, you wanted to switch microphones with James? Thank you.
James, I'm stealing your microphone.
There you go.
I'm just going to hold it. That works? Okay. So we have, as community mediators, there's a national association, and this is one of the demos that they have put up on YouTube. They have some fantastic other videos that are kind of mini mediation lessons. So it's sometimes nice to get questions answered through kind of a role play situation, so you can kind of see it in action. So this is 2 minutes, and it just shows what that opening statement piece is. And that's really important because by the time folks get to this table and are sitting down, they're probably seeing the person they have a really emotional conflict with for the very first time in a long time, or they're looking them eye to eye after kind of glaring at them over the fence for months on end. So it's really key that this opening statement is neutral and welcoming, and it really kind of gets the parties into a place where they can see each other as equals and really begin to have a conversation. And by the time they get here, they've already spoken with you guys. They've already spoken with a case manager at one of our centers. So they've had some human contact, they kind of know what to expect, and they've gotten a letter or two in the mail giving them more information. So they have a pretty good background, but this is kind of the first time that they're all sitting there, and they're usually pretty nervous at this point. So would you hit play?
And if we can put the microphone on the speaker.
I got the microphone right in.
Thank you.
So I haven't had a chance to talk to either of you ahead of time. I'd like to talk a little bit about mediation. First of all, have either of you been in mediation before?
No.
Okay. So I'm a staff person with the Mediation Center. Just wanted to talk to you a little bit about mediation, at least because I practice it. First of all, it's voluntary, so hopefully neither of you have been forced to be here. And I see it as a conversation between the two of you about whatever issues have brought you here. And I see my job as just helping you have that conversation, hopefully being able to get clear about what each of you want, help you work through the issues, hopefully begin to see each other's positions maybe in a little bit different way than you did before you came in, and then helping you figure out what you'd like to do, make good decisions about your conflict, hopefully maybe coming to some ideas that the two of you agree on, but if not, at least a chance for you to hear the other side and make good decisions about your dispute. Does that make sense, or any questions about that?
Not at this point.
Okay. My job is not to make decisions. I'm not a judge. So the decisions are in your hands. I work on the basis of confidentiality, so I'm not going to share anything that's said here. Also, in Ohio, mediation is considered privileged, which just means that I can't be compelled to testify about anything that's said here. And if I take any notes here, or if I take any notes on the board, I destroy those. Those can't be used in a court proceeding. The only exceptions are things like if there was a felony or threats were made or something like that. So really, occasionally we might decide if either of you needs to take a break, just let me know. Occasionally the mediator will think that it's helpful. I might decide to break and meet with each of you separately. If I do that, anything that you say to me in a private session is confidential. I won't share it with the other party unless you specifically ask me to do that. Okay, that doesn't always come up. I just wanted to let you know that in case it does.
So if I could just ask you guys, what's the one thing that struck you the most from that? Shout it out.
Probably the posture that the woman had. She seemed like
it's not just
really on the defensive.
Substantive issues that you're dealing with,
yeah.
but also
she seemed
the
kind of
relationship.
hunched
kind
back.
of just like.
Yeah. Yeah. What else?
The guy seemed nervous. He was a little antsy.
Kind of twitching.
Yeah.
Kind of fiddling with
Fidgeting.
his hand. Yeah. Anything else you guys noticed?
No eye contact.
Yep. So when we say people in conflict, we mean people who are in serious, emotionally blinding conflict with each other.
And just on that note, the confidentiality really encourages parties to be open and honest. That's a big part of it, that they can have conversations without worrying that something they're going to say is going to be used against them later in court or something. So we want the parties to be as honest as possible. Any questions up to this point? I heard you guys were a very inquisitive group, so I'm a little worried. Hasn't been a lot of questions so far. Okay.
No, this is kind of a newer thing for us because we don't really get a lot of people who are looking for mediation services unless it's like parenting classes they have to go to because they're in a divorce. I mean, we really we try to suggest it to some, but you know, it's typically a newer thing for us, or not really newer, but not so often.
Okay, and we're going to cover some of the areas that may be appropriate for mediation.
Okay.
I'm not sure if it's going to be explained as the video progresses, but are they in there for mediation for an interpersonal conflict, or is it like...
We're not going to show more of the video, I don't think. So I'm not sure. Elise, do you know what the video...
I got this one. I think in that particular example, it's a landlord-tenant issue. Like a lot of times when you have a landlord that's not with a big property company, but maybe it's just an individual who has one or two properties, it can be really tricky because maybe there aren't legal processes that are clearly followed all the time. So you end up with some more informal conflict that can happen between tenants and landlords. So I think that's what they were kind of trying to set up in that one.
Okay.
So during the session, the parties may not come to an agreement, they may come to an agreement, or they may want to continue to another session another day. And so in the agreement can be full, they can agree on everything, they can agree on some issues, but not everything. It can be a verbal agreement, written, and if it is written, then the mediator will write it up using the language of the parties, and then will provide copy. They'll have everyone sign it, not the mediators, but all the parties will sign it, and then they'll provide copies for every party. And then after the mediation session, the case manager may follow up if there was an agreement to see how the agreement's going, if there's been compliance, if they need another session, things like that. And then when a final determination is made, yeah, it's been successful, or there's nothing more we can do, we'll close the case out and send the closure letter to the parties. So these are, for community mediation, these are all the types that may be appropriate for community mediation. I'm just going to point out a few of the bigger ones. Business consumer, so that could be anything from, a Craigslist ad. Somebody buys a car on Craigslist and that doesn't work, and there's an issue there. It could be like a formal contract that was signed and things have gone wrong. Children, youth, and school conflict. We can send mediators into like junior high schools if there's issues that the staff there think may be appropriate for mediation. It may be some sort of gossip or some sort of fight, or some conflict between two students or more students that's really affecting the school or affecting the student's ability to learn in that environment. Mediators may be appropriate for that. We do some issues in divorce, unmarried parents, and shared parenting. There's limitations, and the case manager can provide parties more information about what the limitations are on those. But for generally speaking, shared parenting, mediation would be appropriate for that. We do, I'm going to point out, interpersonal ongoing relationships. Sometimes it could just be someone's mad at their cousin, they don't know what to do, and they feel like they don't have the tools to resolve the issue. Mediation may be appropriate for that. Landlord-tenant is huge. A lot of landlords will either do a direct referral, call us themselves and say, I've got these two tenants that are not getting along, noise complaints, or just constantly complaining about each other. Can you call them and invite them to mediate? Sometimes they suggest to the tenants, and the tenants will call us themselves. And mediation tends to work really well I guess I was talking about just between tenants, but we can do between tenants and also a landlord-tenant issue. If there's an eviction notice, we send mediators to housing court, where after the landlord has filed an eviction notice, the tenant is contesting it, the mediator will go to housing court, and before they meet with the judge, the parties will meet with the mediator and see if they can work out a payment plan or a time period of which the tenant can leave, something like that, so they can resolve the issue without having a judgment by the judge. We do neighbor issues. It could be noise complaints, it could be property line disputes, it could be leaves or acorns falling on someone's property, or dog issues, dogs barking, just a wide variety of neighbor issues. Some mediation nonprofits will work with runaway youth and truancy issues. So if there's a youth under 18 that is running away or leaving home or not coming home at night, we can do a mediation between the youth and the parents. Again, this is a voluntary process if all parties are willing to participate in that process. Many mediation nonprofits offer a diversion program in conjunction with county attorneys, where if there's been a low-level offense or a juvenile offense, if the county determines that the matter is appropriate, then it can go through a diversion program, and we offer a restorative justice process where the offender has an opportunity to talk about what they did in front of either the direct victim or community members, and then listen to how this behavior has affected other people, and they have a conversation about it in front of a neutral, and then they come to an agreement to, one, repair the harm that's been caused, and then to give assurance that this behavior won't happen again. And so they come to an agreement of what the offender can do to repair, which can be apology letters, it can be community service, it can be doing some sort of personal development things, such as getting job training or something that might be appropriate for this person. If it was a theft issue, for example, getting job training may be helpful in terms of helping that juvenile secure future employment so money doesn't become an issue for them. So these are a wide variety of things that may be covered. Any questions about what may or may not be appropriate for mediation? Okay. Anything you two want to add about what we cover?
I think this is in the materials that Ellie prepared, but just very clear, we're talking about community we're talking about community mediation under statute 494. So there's a couple things we can't do, and I think she's got that clearly. So we're not talking about divorce. We can't do custody. So that's what it's for when we say parent, divorce, unmarried parents, shared parenting, that type of thing we can do. So family issues we have to be very careful with those referrals. Okay, there used to be the mediation center, but I think we're referring mostly to Volunteer Lawyers Network. Is that what we put in the materials? Yeah, for divorce, people that need sliding scale divorce.
So let me just plant one thing as we go on with the rest of the training, and that is this. And Kathy raised it, is that some of the mediations are being funneled through the court system. So for example, as James talked about, you know, when people are going to housing court, there are mediators there, and there are mediators at other avenues in the court system. But what I think, and as you listen to the rest of the presentation, bear in mind that I suspect you've gotten a number of calls where mediation might have been a good avenue for you to make a referral. For example, I got a call the other day from somebody who's in it sounded like a nursing home or a restorative care facility, who wanted an elderly man who wanted to complain about his mail being opened by the staff. And he wanted a lawyer, okay? That's not a legal issue. You know, that's something that's going on, you know, between somebody being served by a social service provider. And I referred him to mediation rather than to a legal provider. And so I suspect that, you know, as you sit here and you listen to the rest of the presentation, think about where, you know, within the last 2 weeks, calls that you might have gotten where it might have been really appropriate to send him to mediation, to give him a mediation referral instead of a legal referral. Okay? All right. Thanks. In just a second here, let him get the camera back. Sorry to do that to you, James.
Oh. So just on that note, we'll take housing court as an example again. If the landlord is thinking about filing an eviction notice, mediation may be appropriate even before that filing happens. We can provide mediators really early on in the early stages of the conflict. So I just want to make a note, just because we do send mediators to court, we can help nip it in the bud and get it before the court process even begins.
So before they pay the filing fee, before the UD, before any of that happens. So we want to try to keep these in the community where possible.
So here's some tips on what you can say if you think a party may find mediation beneficial. Here's how you may want to describe the process. Our case managers will, as it says here in the yellow, will provide more information and more detail, but here's kind of some general things some points that we think you would want to get across. The mediators are trained professionals. It is a volunteer roster, but everyone does go through a 30-hour training, and then they have to do annual trainings. And the mediators don't make decisions for the parties. It really is party-driven. They can agree to what they agree to, or they can, if the parties don't agree, then they don't have to sign anything. They don't have to make an agreement. It is safe and confidential. We really do emphasize that to all the parties. It's voluntary for everyone. You can opt out at any time. So if they start the process, if they call us and request mediation and the case manager opens the case and contacts the other party, at any time a party can decide, you know, this is not for me, I'm going to opt out. Even at the mediation session, halfway through a session, the party can say, you know, I'm not comfortable here, I'm just going to leave. There's no problem with that. Most mediations for community mediations will be either free or sliding scale services. Different organizations have different pricing schemes, but compared to private mediation, it will always be cheaper. It is separate from the court system. The mediators, case managers cannot give legal advice. So we're not the courts, we're not located in the courthouse. We do send mediators there if there's already been a court filing, but our offices are located elsewhere, and so there's often confusion that we can somehow dismiss their case, but the parties would have, if they agree to dismiss a case, they'd have to take care of that with the court system, not through us. Mediation generally does not close doors to other services. They can do mediation at the same time there's a court case going on, before there's a court case. The only thing that I can think of that it may close doors to another service is if there's a statute of limitations, right? If they have a viable lawsuit, but they only have 2 years to file a lawsuit before the time runs out on that. If they try mediation first, it may or may not close the door to filing a lawsuit later. So that's the only thing I can think of. Otherwise, mediation it's a great alternative. That's not going to close doors for anything else.
Can I jump in for a second?
Yeah, go ahead.
Just to remember that to remember that because mediation is a confidential process, like you saw in the video, mediators can't be called to testify in court. So whatever happens in the mediation session can't be used against the parties if a legal case does arise later. And there are exceptions to that, one being if there's an allegation of child abuse or an allegation of harm to self or others. There are circumstances that the mediators will cover with the parties, but the general rule of thumb is confidential means the mediators can't be called to bring that information up. So the impetus to resolve the case is really high because the honesty of the parties can't hurt them later in a court case.
So questions you may want to ask before referring to mediation. One, where do the parties live? Different nonprofits use different ways of determining whether it's appropriate for that mediation organization. But generally speaking, if one party lives in or works in the area of the mediation nonprofit, that's sufficient. For example, Community Mediation Restorative Services, we serve the western and northern suburbs of Hennepin County, and so if one party lives in New Hope, it doesn't matter whether the other party could live in Florida, and we would still take the case for at least based on the geography qualification. Another question to ask, is it time sensitive? Mediations take a little bit of time to set up. We can't generally do a same-day mediation. So between when they call us and the mediation actually takes place, it could be anywhere from 3 days to a couple weeks to set that up. So if they have a court date tomorrow, mediation is probably not going to be appropriate unless they can extend their court date. Has there been a history of violence? We have to, due to the statute, we have to disqualify many instances of if there's been violence in the past between the parties. The case manager can give the nuances of that, but if there's been a pattern of violence, then it probably won't be appropriate for mediation, because we just, as community mediators, we're not permitted to do that sort of mediation.
And some of these questions now we're getting into are the questions that were given to us by Jackie and some of the other 211 staff. So we're trying to respond to the questions that were asked by staff. Mm-hmm. So
our mediation agreement is binding. If there's a written agreement, we have a form that says the parties intend for this agreement to be binding. Okay, it's only binding, of course, if a judge eventually decides that the agreement is binding. But it's as binding as any other. It's a document between the parties that's signed with both of them saying that they've been advised that they intend this document to be binding, and they've been advised to seek legal advice if they're uncertain about their legal rights. So we tell the parties they intend to be binding. We're going to give them a form like that. It doesn't have to be. They can be a verbal agreement. It can be just a written agreement without binding language, or if they really want to, that extra teeth, we have a form that says the parties intend for this agreement to be binding. And then in the yellow here, if there is a court date, participants can agree to request court dismissal. So in part of the agreement, it might be party A agrees to pay $10,000 on April 1st, but the court date is going to be March 15th. So they agree that they're going to dismiss the court date, and then the payment will be on April 1st. So then one party has to dismiss the court claim through the court, and so they have to do that separate process. What documentation will participants receive? They'll get an initial letter stating that they've requested mediation, and then it gives us, the letter gives them more information about what mediation entails, the limitations, and what they can expect from it, the confidentiality and such. If there is an assigned agreement, all the parties will get a copy of the signed agreement. And then whether there was a mediation or not a mediation, they'll get a closure letter saying they contacted our office and we were unable to schedule a mediation, or we did schedule a mediation and there was an agreement, or there was not. So they'll get an initial letter and then a closure letter and sometimes the actual agreement. What should participants bring to mediation? Different mediation nonprofits have different ways of handling this. Generally speaking, the mediators are not fact finders. They don't need testimony. They don't need 200 pages of evidence. The purpose of the mediation is for the parties to understand each other. So generally speaking, what one party wants the other party to see would be appropriate for them to bring. But the case development staff will have that conversation with all the parties. Can a court order mediation? Yes, the short answer is yes. It's still voluntary for them to participate. They do have to, I believe, show up, but they don't have to come to an agreement. Court-ordered mediation happens most frequently with family court cases, but other areas where it may happen are conciliation court, juvenile court, harassment court. Okay, I'm going to turn over the presentation to Jeanne.
Any questions so far? How are we doing on time?
You're doing fine.
Are we doing okay? Are we okay if I sit, or would you prefer that I stand?
Whatever you prefer.
Can you see me okay? Because that way I can sort of see the doodad. Can you get into this too, so you can be? Is this all right?
That's great.
Okay, and Elise and I are going to try to wrap up the rest of these slides, make sure we've answered all the questions that were asked in advance, and then try to answer any other questions that you may have. Ellie, is this kind of going the way you want, and Emily, and what you're hoping for? Okay.
Keep flying.
Pardon? How are we doing on time? We've got, we're good, okay. So this is kind of the crux of the matter, and this is one of the challenges we all have in our agencies, is that people in conflict don't want to necessarily sit down and work things out with the other person. They want to go to court. They want somebody else to tell the other person that they're right and the other person's wrong. And so one of the things that we do, which I'm sure you all do as well, is try to help convince people to even consider working things out in alternate ways. We want people to know their legal rights. So we will say, call Homeline, and then consider mediation. So know whether your landlord can do this or not, but then also think about, since your landlord is also your cousin, whether you might want to sit down and work this out with the other person. So, and so you can just plant those seeds of mediation, that there are other ways to do this. And so that's part of, there's an art and a science to try to encourage people, but people, we're trained from little kids, mommy, mommy, teacher, teacher, judge, judge, officer, officer, tell that other person they're wrong. And so this is really, you saw the people sitting at the table, sitting down and trying to work things out. And that's harder in some ways for people to do. So even just opening the door, letting them know that they can sit down and have this conversation might plant a seed. And they might not take it up right away, but they might do it at some point in the future. So you're just saying, it sounds like you'd really like to work this out with your neighbor. There's a lot you want to say. So it's not instead of, it's in addition to potentially. So they could still do a court case, and as James said, sit down and work things out. Okay, but we do that all the time, and it's very hard. People, just to pick up the phone in our offices, you have to have the 30-hour basic mediation skills training, because you've got to have those good listening skills, just like you all have, really hearing what those underlying issues are. So some of the things that we found that people hear, because when they're in conflict also, people don't always hear what words get through that conflict experience, that it's low risk, it usually probably won't cost them anything except their time, that they have a say, that anything they say, they can still go to court, and nothing that they say in mediation, as James said, would be used against them, that it's free or sliding fee scale, that it's confidential, so they can even call and talk with a case developer and see if this might work or not, and we can sort of talk with them about it, and that nothing that one person says to us would go to the other person at all. So we'll keep that all that case intake, case development is still confidential. It is actually, you know, less contentious, private, and there's the one thing I really like here, this bullet point, is that there are potentially more solutions than you'd have in the court setting. Things like apologies or working things off. You know, the kids that broke the car window can shovel the snow for the neighbor. You know, it's not just paying the insurance fee. So there's lots of creativity that can happen. And then there's the idea that it's really driven by the participants. They get to say where they meet, when they meet, who's going to be in the room. So we're considered alternative dispute resolution. So in the courts, you don't get to pick who your judge is or what day you go to court, or you have to pay for parking and take time off of work. So here they can do it, on a Thursday at 6 o'clock at the library, and they get to decide that I want to have 3 of the neighbors, as long as everyone agrees. Okay.
On the potentially more solutions, keep in mind things like if you go to court, someone's right and someone's wrong, and someone wins and someone loses. Those are the only, it's a binary function. But with mediation, you can have the kid who broke the window shovel the sidewalk, which helps the elderly person whose window it was get something back. And sometimes even if the elderly person wins in court, they don't get anything back because the kid can't pay restitution through the court system. So there's no closure, there's no reciprocation, and that relationship is irreparably harmed and can't ever be put back together.
So when does mediation work best? First of all, they have to be willing to participate, and usually when the other person gets the letter, they're like, I'm not sure I want to do this, and so they're usually calling with a no, and we have to turn them around to a yes, because again, in conflict. But it usually works best when they have an ongoing relationship, when the participants know each other, when they have some sort of relationship. So we had a call from a woman, and she's calling, and she said conciliation clerk told her to call us. I lent this woman some money, and she hasn't paid me back. Blah blah blah. Right? Oh, by the way, it's my daughter. Guess what? That's a relationship that's probably worth having a conversation about before you take your daughter to court. So, as an example, and then the earlier in the conflict, the better. So, the longer a conflict has been going on, the harder it is to get people to the table and for them to want to work it out. That doesn't mean it's impossible, but it may not take just 1 2-hour session. It may take a while. And pretty much anything has the possibility of people sitting down and working it out as long as they're willing to participate. So things that you think, we had one with 19 911 phone calls. You'd think that would be pretty intractable. It took a couple sessions. These were neighbors. They were able to sit down and work it out.
Especially when there's
Go ahead.
especially when there's a really deep-seated emotional piece, like children shared in common, or somebody's dog is barking, because people have really strong connections to their pets. So when that emotional factor is higher than the factual factor, mediation can be really powerful.
And I just want to add that as a case developer, I have no idea whether something is going to be successfully mediated. Sometimes I'm really surprised when I think mediation is not going to be successful, and then it comes through with an agreement, or I think it'll be a really easy one, and then it becomes really difficult. So it's really hard to predict whether something's going to be successful or not until it actually happens.
So if you can get them to call us or any of the programs, we can take it from there. It's just getting them to even start that phone call, and it's very hard. That's why sometimes it's indirect referrals. If you can, in some of our referral agencies, they'll take the people's names and numbers with, or maybe have signed data privacy and pass them on to us. But even when a police officer comes to the door, they might say, call the mediation program, but they may never call. So it's very hard to sometimes take that next step. So the more you can support, encourage people, the better it can be for us. And that we will, that we will contact them, and that it can be helpful if the other person knows why the matter was referred to mediation. So we're going to be then trying to contact the other person. So I don't know, do you ever talk to 2 sides, or you usually just get the one side? The one side. See, we sometimes get calls that are coming from the both people, but we haven't linked them up, even because we're not sure that they're calling about the same neighbor. Oh, so are you talking about the parking case in Maplewood? No, I'm talking about the parking situation in New Brighton. Okay, great. So those are different ones, but they could be the ones on the same block. We don't necessarily know, and we're linking them up. We also try to frame the issue as broadly as possible. So we try to frame it neutrally and broadly. So it's not going to be the unpaid rent. It's going to be the rent. Or we might even say tenancy issues to keep it open, because maybe the tenant wants to talk about rent, but the landlord really wants to talk about how you're keeping up the common space, for example. So we want to keep that open. All right. Anything else on this I'm missing? Okay. People can, we sort of say they can call themselves. You can ask them to call us. They don't need to speak to anybody else ahead of time. They just can call us and we can take it from there. They can also email us. We're getting way more call initiations by email. I get a little nervous with stuff people put in writing, but we're getting more of that. And then people can fax it. They can email it. They can, just it takes one person to get this started, but we do need to then start collecting names and addresses of the other people. We need some way to contact that other person. Okay, anything?
Just as Jeanne mentioned, everyone who answers the phone at a community mediation center has gone through basic training. They're all really nice people. They pick up the phone because they want to help people resolve their conflict. So if you can just get someone to call one of our numbers, they'll have a pleasant conversation. If nothing else, someone will listen to them and help them feel heard. They're kind people who answer the phones for us.
But sometimes the phone goes to voicemail, and sometimes the person's not there. So we're not perfect. We don't have 24-hour staffing. We aren't able to do, and we don't have the depth of experience, and we don't always have people in Spanish, the bilingual. We don't always have all of that available either. So we will try to get back to people. We're all small. We're all not-for-profit, as James said. So we don't have some of the depth that you might have. So just like if they're calling Homeline, they might need to leave a message, and someone will call them back. Same thing here. So if they try to call us, they can leave a message and call. Somebody will call them back. Now, here's one of the key pieces that people don't always know what mediation is, or they think it means arbitration or meditation or something. They don't know. And so what we find is that it can be helpful to break it down into the simplest possible language. So a chance to work things out with the other person, an opportunity to be heard. You get to say what you want to say. It's safe and respectful. Everyone can talk about their concerns. And so just, sometimes it's just a facilitated conversation, taking it to the easiest language. It sounds like have you had a chance to sit down and talk about this with the other person? You can even ask that question that might then open the door to that conversation. So sometimes using the word mediation can be more of a barrier to people. So just, you sounds like, talking about whatever is important to you. Yes?
I don't know if this was right, but I've had people that are calling like neighbor issues, and I told them that mediation might be a way for them to avoid court.
Exactly.
So, because a court always has an unpleasant connotation, so whenever I mention that, they're like, oh,
that's perfect. Exactly. Yeah. So yeah, it's a way to keep things out of the court, or keep things private, or keep things confidential. So and then they get to control, and then they're in control as well. That's great. Yeah. Avoiding court. Some people want to go to court, or they want to do the 911, but it's a great way. And there's many people who don't want anything to do with the systems that exist. So we are perfect for that as well. So DRC is co-located with public housing, and we have a lot of immigrant and refugee residents, and they don't want anything to do in general with court systems. And so, they know that they can use mediation resources, for example. What could you ask that might determine if it's a good referral? Just some really simple things. What's your nature of the relationship with the other person? If it's your daughter, if it's your cousin, if it's your neighbor, if it's your coworker, those are, that tells you that they may not say it's a relationship. We don't have a relationship. Well, but you're related, or you live next to each other, you have to see each other every day, or, so you help them. And then what would you like to see happen? Just a nice broad sort of, sounds like things have been hard. This has been really stressful for you, or you're under a lot of, this has been really challenging. So just anything that helps them sort of open that up. But even if, as James said, even if they're mediating, we just did a phone mediation yesterday. The person had filed in conciliation court against an out-of-state company. The company initiated the mediation because they don't want to be flying here. So we did it over the phone, and they were able to work it out. And assuming the payment plan goes the way expected, then they will dismiss the court case next month. So it can go a lot of different ways. So they don't necessarily have a relationship, but mediation was perfect for that. So, that creativity comes into play. Am I missing anything?
No, I think that's anytime, a lot of times people won't tell you up front, oh yeah, we see each other every day because this woman happens to be my son's father's mom. So you kind of have to massage them to give you those pieces, but anytime that relationship is ongoing and clearly going to be present in their lives for a long time, repairing that really can do so much good for both parties that the court system just can't even come close to.
And then This is really a tight slide, but I'm sorry about that. But again, how do you help them moving from wanting their legal rights or just that legal right to then considering mediation? And again, it's not either or, so we shouldn't maybe have positioned it like that. They should know what their legal rights are. They should know if what their landlord is doing is right or wrong, but then they get to go to the mediation with that information and make their own decisions. But that, again, they should be invited to consider both. It can be challenging. People want to focus on their rights. So again, sounds like you want to be a good neighbor or you value your job and your workplace and you want this to be a healthy environment. You know, playing to their higher interests, okay? Everybody wants to be a good neighbor. Everybody wants to be a good parent. Everybody wants to be a good friend. So, you know, pardon?
Not all our callers.
There's some small piece of them that really wants to be good.
They be good by getting what they're due out of the other person.
Yeah. Right. But that's where people get really positional. So I really want to, and it may really sound, you know, hugely adversarial. And so, you know, you really want, you know, this is, and so then, and I know we always say that the people who are calling us, you're not seeing them at their best. Because when you're in conflict, at least I can only speak for myself, I have behaved less than honorably, you know, because you're angry and you're upset and you're hurt and you know, and so you're not seeing the people, you know, the way who they really are. And so how do you answer with empathy and try to listen? But I'm sure you get that all the time. You see people. Trudy, did you have a case in mind? Or
no, just in general, a lot of them are, they're sure they know what their rights are and they want them enforced.
Right. And we get that all the time too.
And they may or may not be correct on the first part, but you can't convince them otherwise in the context of the phone call.
Or most of them, especially with the tenant-tenant issue, is by the time they call us, they're livid that the landlord hasn't thrown them out yet.
Right.
You know, that, you know, they watch me. You know, whatever the case may be, but you know, they're very angry that the landlord has yet to do anything, and they've complained and complained and complained and complained, and now they want to know what they can do on their end to make that person leave them alone.
And this is this might be a perfect thing, because they could you know, does the neighbor even know that you want them to leave them alone? Sometimes they have never even had that conversation. They may not even know their neighbor's name, so you might send it to apartment 211 from apartment 212, right? You know, they haven't ever had that chance to sit down and have that conversation.
Okay. And the fact that they've been communicating with the landlord and the landlord hasn't heard them and hasn't taken action, it's a great opportunity for them to go directly to the other person and say, okay, I asked the landlord and they didn't do anything, so now I'm asking you.
So let us sit down and try to work this out. Because if James is our landlord and we're both going to James, right, and he lives out of state, he doesn't care, you know, hypothetically, you know. But then, you know, so if Elise initiates and says she wants to mediate with me, you know, then I may not even know that she has a concern. We just did a mediation between a Somali family and a Hmong family. Okay, so we had interpreters. This was in one of the public housing high-rises, and it had interpreters, but one of the families did not know that the other family was having this huge issue. So it's very often that the other person does not know, or does not know the extent or the magnitude of the conflict that they've had. Okay. And then we also say that some things do belong in court. I mean, and so people do have the right to go to court. They have the right to, you know, there's a case in Connecticut where they're spending $300,000 over fence issues, okay? Now, they could mediate that, or they can spend all their extra money litigating, and maybe that's how they enjoy their free time and what they really want to do. But there's also, you know, there's reasons that we have courts, and there's reasons that we have our legal system. So even though that we're alternative, we don't think that we're always right in every situation. That's part of it too. So if you feel somebody's being taken advantage of or being, you know, then maybe mediation, if it's not a level playing field like domestic violence, we're not going to mediate those types of cases. So, you know, we want to make sure that those get referred to the right places where they can have an advocate, they can have, like the Children's Legal Aid, you know, people acting on behalf of the right people acting on behalf. But once you know, there are so many cases that are appropriate for mediation.
Have you ever done mediation between children and their parents, as in older adults with their elderly parents, and, you know, the safety issues of the parents being on their own anymore, but you got, you know, your feet, you know, steadfast in the ground and don't want to consider assisted living or anything like that. But, you know, the children either live out of town or live out of state, and there's no one here. You know what I mean?
We're seeing more and more of that. And we all do some form of elder care. Do you want to, James?
I'll just jump in a little bit. So we offer for our mediators special training in areas of family law and sometimes even specifically elder issues. Okay. And so the mediation intake person or the case manager will pull from that roster of the more qualified mediators. Jeanne, you can add.
Elise, I know you do a lot of elder mediation.
Yeah, same thing, that we have a special training that we do every other year for elder care issues. We also work in a couple different assisted living facilities, so we can do resident-resident issues that are occurring once folks get in there. But we also help with that kind of initial meeting of getting a potential resident to come see a facility. Sometimes that conversation can happen outside of the facility.
Okay. Any type of difficult conversation. We've had cases where maybe a caseworker, a social worker at a hospital might call and say, all of a sudden the 8 adult children are flying in from all over the country, and they haven't seen each other in 5 years, and they have to make some tough decisions potentially. And so we can be there to help them have that conversation, which is. We
get a lot of that. We get a lot of calls from out of state. Their elderly parents are here in town. Parents don't want to agree that they should downsize or move to something else, and they can't come here. They can't be here at the drop of the hat or something like that. So that's really good to know that you can do something like that.
We can do some of the mediation, but they also might want to look into getting, some of the caregiver resources or some of the social, all those other things as well. So or they've flown in and they've been here for a week because mom fell and now they need to go home, and but they every time they bring it up she gets mad and stuff like that. So we can help structure that conversation and help it be something where everybody has a voice and nobody feels ganged up on or picked on, and so that can be helpful. That could be one way to do it.
Yeah, because I think a lot of it is it's hard for them because they don't think of it until mom falls, or they're at that late early stages of something, so it becomes more. Of course, the parent would become more defensive. So that's good to know. That's because I get a lot of that on weekends.
Oh, really? Interesting. Yeah, we can tell the seasons by the calls we get. Snow, trees, kids. Yeah, I'm sure you get the same thing. Okay. Yeah.
Is there a size limit to the groups that you can work with?
We had a victim offender one that had 5 offenders and 103 victims. I think that was probably the biggest. So just to give you, in terms of trying to work with a large group like that, it could be an entire work group. It could be, so we might use a different sort of process. What's the largest cases you guys have done?
I don't know what the largest is, but we're currently doing a case in a middle school that involves 14 students who got in a fight. And then we would utilize group facilitation methods and some restorative circle practices. So we have different forms of the same kind of basic facilitative mediation skills that we can employ based on the group and demographics.
Cool. I have a question.
I just want to add real quick. Some of our mediations are one mediator. Sometimes we use 2 mediators to I don't know how many mediators you use with 100.
Yeah, we have 3 facilitators for that large group one, yeah.
So we accommodate our resources for those large numbers.
Yeah. Sorry, we had another question?
Yes. Are you able to always go out to the people, or do they mostly come to you?
I think one of the concepts of community mediation is that the mediators
Excuse me.
I'm sorry.
Why don't you answer that again, but go ahead and just leave that clipped on because they can share the other one.
Oh, okay. Did you hear the question? Should we repeat that, or is
the question was clear? Thanks.
Okay. One of the concepts is that we try to send the mediators to where the participants feel most comfortable. Sometimes where they feel most comfortable is the office space. But that's not our default. Our question is, where would you like to meet? When would you like to meet? Who should be in the room? So we'll use libraries, community centers, faith-based organizations, wherever people feel comfortable. So. But yeah, we also have office space where people can come to. So if they want to meet at 8 in the morning and then the library is open until 10,
Which happens in some parts of the state.
Right, well, it happens in St. Paul all the time. So, but our office, so they could meet in our office, but can they come up with somewhere? And then we'll send the mediators, and we usually do use a co-mediation model, but that gives, the more ownership people have of the process from the start, to choose to do this, where and when and who, the more control they have all throughout. So that's really what this is about. The court tells you show up at 2 o'clock on Tuesday. We say, where, when, who? And that's, so it is that alternative. And people are like, why aren't you just telling me what to do? It's like, because
it's your life.
Yeah, it's your it's your conflict, and what can we do? So.
Have you ever mediated for families that had a parent that passed away and they have a large family and it comes down to distributing what's in the home? Because I have a large family and I have a feeling that may happen. So
who gets the yellow plate, right?
Yeah,
Grandma's yellow
exactly.
plate. That's there's a whole book about that.
The bronze horse statue. Where does that go?
Whatever it is.
Yeah.
You've done that, haven't you?
Yeah, and that does happen frequently, and especially if there's, if it looks like it's going to become a long, protracted court battle in probate court about some of the property, sometimes it's nice to get the family on the same page and to give them a chance to sit down in a place and talk about it.
Okay. We had a case once, they actually both had attorneys. We usually deal with people who are pro se, people that don't have representation, but sometimes they have legal aid, sometimes they have their own, actually they do have attorneys that they've hired. In this case, it was step-siblings, and there was, the parents had died, and the attorney who contacted us said, these decisions they make over the shed and what was in the shed will determine whether they ever have contact with each other again. Are they going to go their separate ways as step siblings and never see each other again? Or are they going to be able to work this out in a way that they're going to be able to, maybe see each other over the holidays or continue to have a family? So that was, I thought, very insightful on the part of the attorney to say, let's try to not have this be divisive. Let's try to bring this family, use this opportunity to bring the family together. Because you see those things falling apart. Who gets the cabin? Who gets the two, grandma's bowl, truly.
I have a question about the confidentiality. So the mediator is like, they're not going to say anything, but how do you make sure that the two participants keep it confidential? Or do they have to sign a thing, or?
Yeah, truly, it's up to the participants what they keep confidential and what they don't.
And they, so every mediation starts with that opening statement, and then the opening statement ends with, and here's a copy of the mediation agreement. Do you agree to all these things? If you do, you sign it, and we, the mediators, sign it. So everyone in the room has signed this contract that now says, we're going to be respectful, we're going to keep this confidential, we're going to follow the, kind of concept that is mediation. Mm-hmm. Whether they uphold it or not is really up to them.
That's where case law gets made around mediation.
I think the important thing to tell them is it cannot be used in court. It's not admissible as evidence. So no matter what they do with it, it cannot be presented in court against them.
If they could have gotten it any other way, though, is the question. So, yeah.
So generally speaking, if a party goes in front of a judge and says, in mediation, the other party said such and such, the judge generally won't listen to that.
Okay. So unless they have that document that says, we would like this a binding document.
Well, they look at the agreement is not. The agreement, the nonprofits don't share the agreement with people, but the agreement is not confidential for the parties. Unless they choose to make it confidential.
They have the choice in that too. We're going to agree that at the end of, so we have the things that set out at the beginning, the agreement to mediate, and then if they reach a written agreement at the end, they can say we're going to not talk about this with anyone else, or we're going to take this information to this person. So that's one of the things the mediators will close out the conversation. Who gets to know about what happened in this room?
Setting your privacy settings on Facebook.
Correct.
Right.
They get to, it's a very nice analogy. They get to decide what's their privacy. We did a mediation with a couple of neighbors in a high-rise, public housing high-rise, and their conflict had been so intense that it had affected the whole building. You know how two people's conflict can take over everything? And they mediated and they said, let's go to lunch and freak everybody out. Because the minute everybody saw them talking to each other, they knew, what's going on? But what happened in the mediation was still confidential, but everybody could tell that they had done something that changed the nature of the relationship. And that's what we're really all about. We're trying to transform that relationship around the conflict. And so trying to keep, the conflict can be something healthy, if they can sit down and work it out. If they don't, they're going to get stuck, and that's where you get the mental and the physical, you can see it, it can take a real toll on people. So this is a healthy, normal thing we want people to be able to do.
that conflict happens. It just happens. We're human. There will be conflict. So give folks the tools to see that there's another way to potentially resolve it in this situation and beyond as they go through the rest of the relationships.
Did you want to?
Yeah, I do, but I'll go off for a second. All right, I just wanted to add a little bit of perspective just to, I mean, this has been a wonderful presentation, but let me give you some perspective from a practicing lawyer, you know, who has 29 years of trial experience. I am actually a certified family law mediator, at least I was. I'm no longer certified, but I went through mediation training, so I have a real good understanding of what these folks do, as well as I've been on their side of the table trying to do the mediation, just like we saw in the video. But in addition to that, as some of you may remember, I was a trial lawyer representing, for the most part, defendants in very, very high exposure personal injury and death cases. I represented companies in the transportation field that would run over or run through or whatever, kill people or maim them. And so I have been personally representing people in mediations, probably I would guess at least 200 mediations in my career. And so I can tell you, as these guys are talking about mediation, it is about conflict. It is about people feeling that they've been wronged, you know, and they want someone to change the world for them, to vindicate them from what their wrong is. But I also had this thing when I was a lawyer that I called Krug's rule. I've been practicing long enough, I could make my own rules up. And Krug's rule was this, is that in litigation, and this is, I think, important for you to hear, that in the end, it really doesn't matter what you, the person who is wronged, thinks, nor does it matter really what the purported wrongdoer thinks, nor does it even matter what their lawyers think or what their families think. Doesn't matter. In the end, all that matters is what the judge thinks or the jury thinks. That's it, the people who make the decisions. And if you understand Krug's rule, then you understand how O.J. Simpson could get off on 2 murder charges. Because it didn't matter what everybody thought in the courtroom, only what the jury thought. If you understand that rule then it makes mediation sound like, wow, this isn't such a bad deal. Because with mediation, as we've heard, it is the process where the parties, the people involved in the dispute, get to have some say about how the dispute is going to be resolved. Now, most of the time, it involves some form of compromise. You know, you go in and, you know, you want that neighbor to take the fence down. The fence has got to come down, okay? You know, and in the end, you may walk out with, well, the fence is going to be painted a nicer color instead of it having to come down. Okay, so there's a compromise on both sides because the fence owner probably didn't want to have to paint the fence. But in the end, that is really what the reality is about mediation. You know, and I also have this saying about, and I do a lot of speaking, and our legal liaisons have heard this as well, about human-to-human contact. That the way the world works, the way that it works wrongly is when human-to-human contact isn't very productive, but it works extremely well when human-to-human contact, that is talking to each other, actually produces some understanding and then some commonality. Oh, we really do have this in common. Oh, we really want the neighborhood to actually be a nice place to live. You know, those, or, you know, yes, we want the hallway in the apartment building to look nice. We both agree with that, okay? You may like orange, I may like blue. Well, we're gonna have to pick chartreuse as the color for the walls. So, and so what mediation does is it allows people to have some element of control and some say in what they do. I predict that as we go and do our training, we're going to come back to this mediation stuff more frequently than what we've ever talked about it before. And I think that because as you go forward and do your calls and you know, take your calls and do your jobs exceedingly well, I predict that now you're going to think of, whoa, maybe this is a referral to give both a legal referral as well as a mediation referral. And I don't propose that in 7 or 8 minutes or 10 minutes, you're going to be able to educate somebody on all the advantages of mediation. But what you can do is you can say a couple of things. And you can say, let me also, though, give you a referral to a mediation service. Well, what is mediation? It's a process by which the parties informally get together and they resolve their dispute. Well, why would I want to do that? Well, because if you want to go get the lawyer, it's going to take you a lot more time, and you're going to probably have to put up with whatever is bothering you, you know, the barking dog or the relative who wants the yellow plate or whatever. You're going to have to, that's going to take a lot longer to deal with it that way than what mediation is. But why I don't want to do mediation, you don't need to. All you need to do is to call them. And you guys heard, they've got people on the phones that are just real empathetic and they want to talk to people. You know, do it. I mean, my goodness. I can already see some of you saying, hold on, you don't need to tell me the story. Call mediation service. You know, and so, but what you can do, all right, without doing the whole big education and all that, but you can do something incredibly important, and that is plant the seed. And we all know as human beings, you know, how many of us have said, I'll never do that? I mean, I could give you 2 full pages, single-spaced, bullet-pointed, about all the things I ever said in my life I would never do, but I ended up doing them, this being one of them. So, so you know, so you can plant the seed, and I think that would be good. I also wanted to just mention here, we've got Zoe, and so this month, Zoe Zoe's moved to the burbs, and I'll tell you what, we're coming back in, you know, in a couple, 3 months with a whole new, you know, all around. I don't know if Zoe will be with us. There might be somebody else. This may be our last time we see Zoe because she's doing pretty good, but who knows?
No, it's her neighbor. She drove them crazy.
Yeah, exactly.
So we have Zoe and Mrs. Weiner.
Mrs. Weiner.
And Zoe being, you know, a good egg who moves into the burbs. They share a driveway. And Mrs. Weiner likes to not thank Zoe for shoveling the driveway. Zoe being good-natured, lets it go by. Mrs. Weiner, who complains about the painter's truck in Zoe's driveway, even though it's not bothering, you know, Mrs. Weiner's egress or access. Zoe accedes to Mrs. Weiner. And then we have Mrs. Weiner calling the fire department when Zoe has a fire in her fire pit in the backyard. And finally, Zoe's realizing this is a problem that's not going to go away. So that's where we're at. I'd appreciate our speakers' perspectives about Zoe. You have about 2 minutes to do that. But you know, what are your thoughts, and how, if Zoe called, because Zoe's called now, what, about 12, 15 times? You know, she's a regular. So Trudy's talked to her 4 times already.
She's got a file.
She's got a file.
Second right.
So what are your thoughts about Zoe? And I'll step out of the camera frame.
I'll start. So Zoe is a perfect candidate for mediation because Zoe clearly has a relationship that's not going anywhere. It's not like Mrs. Weiner's moving, and it sounds like Zoe's pretty happy living where she is. But the reality is these 2 human beings see each other every day. So the nicest part, in my mind, is that Zoe doesn't have to talk to Mrs. Weiner before mediation. And by the time Zoe and Mrs. Weiner show up for mediation, they both will have had long conversations with the case manager who will have allayed all of their fears and made them feel very comfortable and helped them see how this is going to be a process that's self-directed. So by the time, even in the interim that it takes for the mediation to be scheduled, for both parties to agree to a time and a location and to get volunteer mediators out there, even during that process, the tension in that household is going to go way down because they'll both feel like something's happening that's progress. So all of that stress and emotional gunk starts to kind of simmer down, and by the time they get to mediation and have this amazing, transformative 2-hour-long conversation where they realize that they have much in common, and both of their parents were Polish immigrants and they never knew, and they can speak Polish together and they're so happy. By the time they get to that point, all of that other stress that may have been related to the fire pit or the fence or the snow shoveling. All of that stuff gets wrapped into this new relationship that's in a much better place, so it doesn't happen again. There's no repeat of that next winter, because now Mrs. Weiner's going to know that she wants to thank Zoe. Not that she needs to, but that she wants to thank Zoe, because she'll understand what that meant to Zoe last year.
Sounds good to me. I just want to add, if Mrs. Weiner is uncomfortable facing Zoe face to face, we can put them in separate rooms and have the mediator go back and forth, and then eventually put them in the same room, or they can start in the same room and then go to separate rooms if comfort level of facing your neighbor face to face is really difficult for one of the parties.
And just to get to some of the logistics, so it's Zoe that's calling the mediation center, right? And Zoe calls, and we'll ask Zoe how she'd like us to approach Mrs. Weiner. Does she want to go next door and say, Mrs. Weiner, would you like to sit down and mediate? Because sometimes they have that relationship, they can initiate it themselves. But as James said, we usually send the letter so Mrs. Weiner will get a letter in the mail that says that Zoe wants to talk about neighbor relations, right? And we always try to prep Zoe to say one of 4 things is going to happen sometimes, so that Zoe knows. So the letter comes in the mail. The letter asks Mrs. Weiner to call the mediation program, okay? But sometimes the person will get the letter and go, wow, I didn't know this was such a big problem. And they'll come over and ring the doorbell, and the 2 of them will work it out on their own. So sometimes they will just take care of it. I didn't know this was such a problem, okay? Probably not in this case.
Sounds like she knows.
She knows. Okay, so that's the first thing that can happen. The second thing, and the easiest thing, is that maybe Mrs. Weiner knows what mediation is. She's familiar with it. She might call the program and says, yes, I really want to do this, okay? The next thing is that Mrs. Weiner might call and say, no, I don't want to do this. And then we have that opportunity on that phone call, we hope, to be able to talk with Mrs. Weiner about what she values in the neighborhood, what's important to her, you know, under what circumstances might she consider just sitting down with Zoe, you know, to help her think about maybe doing this. So sometimes we can turn a no into a yes, but sometimes, as James said in the PowerPoint, if she says no, we're going to send a letter that says, in Minnesota, mediation is voluntary. Right now, not everyone is willing to participate. Therefore, we're going to close your case. But our experience shows that sometimes things change, and that you can open this. Anyone can reinitiate this case at any point. So maybe in 6 months, Mrs. Weiner calls us and says, I want to mediate. And then the 4th thing that can happen is that sometimes we don't hear from the other person. We'll send a second letter if we don't hear from the person again, because this is Minnesota. And then we'll close the case and just say we haven't been able to contact the other person. In the extreme cases of neighbor conflicts, you'll have one of the neighbors will actually sell their house and move. You know, they will say, I don't want to do this, I don't want to work this out, I'm going to put my house on the market. And so that's the worst case scenario. Elise described the best case, what we really hope for. But if we can't get people to the table, that's sort of the path they go, is then the litigation or the moving, or it escalates. And so this is the beautiful thing.
Great. So let me just, as we close here, share a story with one of the more memorable mediations that I had as a trial lawyer. War story. I represented a trucking company whose driver one morning, I mean, we're talking 5:30, 6 o'clock in the morning, was backing up on a 2-lane roadway, blocking the roadway. It was a horrible accident, and it ended up a man driving a minivan who had already had some issues with his legs, ended up getting pinned underneath the truck, and was in the vehicle for a number of hours before he could be extricated and taken to the hospital. Very long recovery afterwards. And he was a nice man, and he had a wife, and he had some adult children, and he was not one of these folks that was exceedingly angry, although his family was, but he was exceedingly hurt physically, and it translated to some very serious injury, you know, emotional injuries, depression, and things of that. We mediated that case with a federal magistrate, and I had, you know, as a trial lawyer, you take people's depositions, you get to know these people, whether you want to or not, you get to know them, and And he was a really nice man. And as a trial lawyer, I always have the opportunity to either be a good advocate or to be, you know, kind of a very difficult person. Many of my clients enjoyed the fact that there were occasions I could be a very difficult person to the other side, and that's what helped my career. But with this person, it was really difficult to be a difficult person. So we mediated the case, and it was, as James said, it was one of those processes where you're in the room together to begin with, and then you separate, and the judge, the magistrate, went back and forth, and I called it shuttle diplomacy, and ended up getting the case settled. But this is what makes the mediation memorable, was that at the end of the mediation, the man and his wife asked to come back into the room to talk to me. And my client was out of town, and they were on the telephone, and they had their contact. We settled the case, and so they were off the phone. But the man and wife came back in, and the man, I actually won't ever forget this. The man told me that he really thought I was a really decent person, and that the case wouldn't have settled if I had been more difficult, if I hadn't been a nice person. And that mediation allowed that to happen because the mediator knew me, the judge knew me, the magistrate, and could reinforce that I was a good person, but also that I was a good lawyer, you know. But it was very touching because what that did, what that person telling me, what it represented to me was exactly what we've heard here, which is you get beyond all of the fighting, you get beyond the facade, and you realize that it's human beings involved in what this process is. So, and I know that you guys, you do a great job on the phone, and what you do is you represent being human beings to people who are in need, people who are in distress, and as we've talked before, you are exceedingly crucial. You may be the first human being people talk to as they've entered into a crisis of some type. And so that's what makes it so wonderful to work with you and to train you. And now you know more about mediation, right? And so as we go forward, I'm going to bet you going to be more situations where you're now going to be thinking, oh, maybe I'll give the legal referral, but I'll also give the mediation one, and I will say, you know, think about it. That's all you have to do. So I want to thank our speakers. They've done a great job. Thank you for coming, and we really appreciate your attention.